Okay, let's start our webinar today. Okay.
Good morning and good evening. I'm Yuko Miwata, the Director of the Office for Trade Remedy Investigations, Ministry of Economy, Trade and Industry. Thank you for joining us today. As the time has arrived, the international webinar on Trade Remedy Investigations 2021 will now begin. First of all, Mr. Kazeki, Director General of the Trade Control Department, Trade and Economic Cooperation Bureau, would like to make introductory remarks and explain the purpose of this seminar. Please.
Yeah, thank you, Ms. Miyata. So let me start my opening remark. My name is Jun Kazeki, Director General, Trade Control Department, Trade and Economic Cooperation Bureau, Ministry of Economy, Trade and Industry of Japan. So I would like to thank you all for participating in the international webinar on Trade Remedy Investigation 2021. Although some of you may have to start early in the morning due to the time difference. Today, we have speakers from the WTO Secretariat, the United States, the European Union, Australia, and Brazil, who are experts in trade remedy investigations and will discuss the global trade in trade remedy measures, the trends in a measure of each country, and the challenges for the implementation of measures. In the current environment of significant changes in trade structures due to COVID-19 disruptions and the increasing complexity of supply chains, we would like to discuss how we should approach trade remedy measures. To begin, I would like to briefly explain the current status of Japan's trade remedy measures before turning to the presentations by today's speakers. So let me start with my brief presentation in Japan. Okay, let's start with the first slide. Okay. In Japan, the use of AD measures has become more active in recent years compared with prior periods. There were cases in which small and medium-sized companies and industry associations applied for new AD measures and sought to continue existing measures by requesting sunset review investigations. On the other hand, Japan imposed only one CVD measures, D-RAMS from Korea, in 2006. Next slide, please. Because trade structures have become more complex with development of global supply chains, CVD measures are an essential tool to redress market-distorting government activities, such as massive industrial subsidies, and to ensure a level playing field. In February 2021, METI launched a forum to solicit the views of trade remedy experts regarding the challenges for the practical use of CVD measures in Japan and actions to address those challenges. Next slide, please. Mainly, three challenges were identified: the difficulty in obtaining information on foreign subsidies, concerns about retaliation from exporting countries, and the lack of awareness of CVD. These three challenges were outstanding. The Subcommittee on Trade Remedy Measures of the Industrial Structure Council has discussed and analyzed those challenges, and the subcommittee submitted its recommendations on August 30th, 2021. Based on the recommendations, METI will collect know-how on subsidies, including through dialogues with other investigating authorities, proactively provide information to domestic companies, and prepare a consultation contact point for CVD applications. So this is a very brief presentation from my side, and this concludes my introduction of the recent discussions on CVD measures in Japan, as well as the trend of the AD and CVD in Japan. Today, we will consider broader topics of trade remedy measures in this webinar, and I believe that today's discussion will also helpful for Japan and all the world to address the challenges of CVD measures. And today we have only 1 hour and a half in total, but I hope we can have candid, frank discussions with all of you. Thank you. First, I would like to start with introduction of today's speakers. Ms. Clarice Morgan, Director of the Rules Division of the WTO Secretariat. Mr. Ryan Majoros, Deputy Assistant Secretary for Policy and Negotiations, International Trade Administration, U.S. Department of Commerce. Mr. Denis Roudonet, Deputy Director General for Trade and Chief Trade Enforcement Officer, European Commission. Dr. Bradley Armstrong, Commissioner of the Anti-Dumping Commission, Australia. Ms. Amanda Asaiti Linehouse Maltese Rivera, Under Secretary of Trade Remedies and Public Interest, Ministry of Economy of Brazil, Economy in Brazil. Now let's start the presentation. First, we would like to hear the views from Clarice about the global trend of trade remedies, and I would like to hear what kind of challenges or changes have happened and ongoing statistics will be introduced amid the changes of trade structure due to the COVID-19 disruptions. After that, each country, the representative will introduce their recent practice of trade remedy measures and the challenges and actions in response to the changes in industrial and trade structure. So again, please keep your camera and microphone off when another presentation is going on. So first, I would ask Clarice for the presentation, followed by Ryan, Denis, and Bradley, and finally Amanda. So that's the order. So now the Clarice, the floor is yours. So please start your presentation.
Okay, so if we could go to the next slide, please. So here we have just a very biggest overview possible of trade remedies if we're talking about AD, CVD, and safeguards. The initiations of investigations since 1995 until the end of 2020. And I don't have more up-to-date statistics because we are just now collecting the semi-annual reports for the first half of 2021. So this is as much as we have at the WTO right now. But you can see, as usual, anti-dumping is by far, the biggest of the trade remedies. Countervail is a pretty sizable wedge these days, and safeguards also. So all areas are fairly active, but of course, anti-dumping over time has been the big one. Okay, next slide. And actually 2 more slides, this one, yeah. Okay, this is year by year the total number of anti-dumping initiations since 1995. And you can see that there is fluctuation over time. The highest number ever in 1 year was 372 in 2001. And interestingly, 2020 was almost at that level. So it's the 3rd highest year since we've been under the Uruguay Round agreements. And not sure how it's going to look for 2021, but I think we will see also a significant degree of activity. So certainly in the last few years, there's been this uptrend, fairly substantial uptrend. Okay, next slide. And here we have a breakout for the whole period 1995 to 2020 of the major users of anti-dumping measured by number of initiations over that total period. And very interestingly, India is in the lead by a considerable margin, and India has over the recent period been consistently in the very top of the the initiators of anti-dumping, followed by the US, and with a considerable lag, then the European Union, and then Brazil, Argentina, Australia, then China, etc. So you can see that it's a mixed group of developed and developing members of the WTO who use anti-dumping on a fairly substantial basis. Next slide. And when we look at this one, we can see that this is the more recent period since 2016, and it sort of amplifies the importance of India and the US as the main users of anti-dumping in the most recent years, compared with everybody else who is also using the trade remedy measures, because you have, you know, Argentina, Canada, Australia, China, EU, Pakistan at sort of similar levels and much lower than the two leaders. Okay, next please. This is what we have for just 2020, the 1 year by itself. And India and the US are about 50-50. And then interestingly, Canada has come up in terms of its ranking. And some who haven't been that active recently, Thailand, Malaysia, and Vietnam, have kind of gotten on the map a little bit in 2020, a little bit more than they had in the past. So it does move around from year to year, but the main users tend to be pretty stable group. Okay, next please. This is just quickly the total number of WTO members who have initiated investigations in a given year. And what I find interesting here is it's pretty stable. I mean, the composition has changed a bit, but it's hovering in the 20s most years, with a peak around 29, and then, you know, sort of low to mid 20s otherwise. And that's been the pattern since 1995 or 1996. So it's not like it's a growing number of users. It's a sort of a changing mix of users, it would seem. Next slide. Now we're talking about the measures applied, the numbers of measures applied based on investigations. And what you can notice here, if you think back to the previous couple of slides, is you see that there is a lag, of course, which as investigators you know well, that it's not that you initiate a case and apply a measure in the same calendar year. Typically, that's relatively rare. And so the numbers in the most recent period of measures applied are showing a downtrend. I think given the number of initiations that was registered in 2020, we would presumably then in 2021 and 2022 see an uptick in the number of measures applied if it follows the historical pattern of the usual lag that we see. Okay, next slide. And here again is the composition of who is applying measures. And it's pretty similar composition, which makes perfect sense. And again, you have India and the US in the lead, and then the EU, Argentina, Brazil, China, etc. And so again, you have a mix, the same mix of developing members who are in fact applying measures after they've taken investigations. Okay, next. Now we look at the targets or the subjects of the investigations, and it's probably not a surprise to anybody who's looking here that China has been the main focus of anti-dumping initiations over the total period 1995 to 2020. You know, it's about 3 times more initiations on Chinese goods than on the next subject member, which would be Korea. So very much of a use of anti-dumping in respect of China, and then followed by Korea, Chinese Taipei, the US, India, Thailand, etc. So so that's a pretty, you know, interesting pattern that we see there. Okay, next slide. And if we look at the more recent period, 2016 to 2020, it's very similar. It's just fewer cases, obviously, because a shorter period. And again, China would be the main subject of the anti-dumping initiations, followed by Korea, and then a range of others, many of which are Asian countries as it happens, which is also an interesting development, I guess. Next slide. Here we have a sectoral breakout of initiations by product sector, broad product sector. And here again, I think it's not very surprising that you see metals and chemicals and plastics as the leading sectors that are the subject of anti-dumping investigations. Metals, certainly steel is one of the big ones, aluminum, and many chemical products and plastics products also tend to be regularly the subject of anti-dumping investigations. And so the statistics for this whole period, 95 to 2020, bear out what we might read in the news as sort of anecdotally. Okay, next slide. And this is just for 2020. And what's interesting is that in this most recent period, plastics and chemicals have reversed in terms of their importance. Plastics is now number 2 after metals. And textiles has come up, which it was not really showing as a significant separate subject sector in the compiled period since 95. So so those are some interesting trends in the most recent data. Okay, next we'll move on to countervail. And here we can see that countervail has shown a sort of a different pattern from anti-dumping. Anti-dumping looked rather cyclical in terms of number of initiations over this period since 1995. And countervail, we are seeing more of an upward trend since the late 2000s. Things started to go more in a steadily up direction, and we have had in 2018 and 2020 the highest numbers of initiations that we've seen since 1995, so 55 initiations in each year. So clearly there has been some growing use of countervail, although of course the numbers are much smaller than for anti-dumping. Okay, next. And this is the number of countervailing measures that are applied in each of the years that we've looked at. And again, you do see this same sort of a lag. You see the upward trend in the number of measures, which sort of tracks, but there's a little bit of a lag. So probably in 2021, we would see a higher number than what we've seen in 2020, based upon the number of initiations that had happened in 2020 for countervail. Next. When we look at who are the principal users of countervail and principal investigators, we see the US in the lead, quite a bit higher than any of the other members that we've looked at here. EU is in second place, Canada, then Australia, then India, and China. So you have more use of countervail by developed members at this point, over the cumulative period, than is the case in anti-dumping, whereas we saw it's a more mixed pattern. Okay, next. And this is the more recent period since 2016. What's interesting here is that in this more recent period, India has come up in importance as a user of countervail. It's now in second place in that most recent period. And the EU, which had been in second place over the cumulative period, has dropped down to, I think, fifth place. So there is some rearrangement or change of composition of who is more recently using countervail than had been the case in the past. Okay, next, please. This is just a breakout like we saw for anti-dumping for 2020 by itself. And interestingly, in 2020 alone, you have the US in first place still, then Australia in second place, and India in third, with Australia and India quite similar, and then followed by Canada, and then China. So and then the EU. So really the who is taking more actions in any given year does seem to move around a bit, which is similar to what we saw in anti-dumping. But it's interesting to see, who are accounting for a considerable portion of the totals in the recent period. Okay, next, please. Here again, we're now looking for 95 to 2020 at the total initiations by the subject of the investigation. Here, as is the case in anti-dumping, China is the leading subject with 189 rather initiations total over that period, followed by India, and then Korea, Indonesia, Turkey, then the US, and then a number of other members. This is again an interesting pattern that we see of a lot of developing members being the subject of CVDs over this total period. Next, please. And if we look at this is 2015, not sure why it's a different period, but anyway, a more recent period, we see, I think the interesting thing here is that the sort of predominance of China as a subject has gotten more in this more recent period than over the total period since 1995. So China with 90 initiations on its products, followed by India, which is in second place with 22. So it's quite a big gap. Okay, next, please. Yeah, okay. Here we have a sectoral breakout. It's pretty similar to what we saw in anti-dumping. So metals and plastics and chemicals in the top slots. And then interestingly here followed by foodstuffs, and perhaps that's a reflection of agriculture products. I'm not sure exactly what's in there, but that may be part of the explanation there. Okay, next, please. And for 2020, we see that metals has grown quite a bit in terms of its share of total initiations of countervailing investigations. Now it's at almost 60%, and for the whole period since 1995, it was 45. So it really grew by 15 percentage points. Chemicals in second place. And plastics doesn't register for some reason in 2020, whereas machinery and other manufacturers have sort of emerged as a kind of a separate breakout with big enough numbers to be separately broken out. So that's a kind of an interesting shift. I'm not sure exactly what that reflects, but it is kind of noteworthy. Okay, next. So now we go briefly to safeguard measures. And safeguards, of course, have the smallest numbers of any of the trade remedies in terms of total number of actions taken. And what we have seen in the last couple of years is levels of safeguard activity that are, some of the highest that have been on record, especially in 2019 when there were 30 initiations. 2020 was fewer. Anecdotally, 2021 looks very, very active in the safeguards arena. I'm not sure how many new initiations there are, but clearly the activity level in general seems to be going up. Okay, next slide. And sort of a similar pattern with the number of measures applied. What's interesting is if you compare the absolute figures, you see that somewhat less than half of the cases initiated end up leading to the application of measures. You had 30 and 23 initiations in 2019 and 2020, and in those years you had 12 measures applied in each year. And of course, there is the lag between investigations and application of measures. But I think as with the other trade remedies, it's clear that the numbers of initiations are always quite a lot higher than the total number of measures applied. So things do fall out of the as a result of negative determinations or sometimes settlements and things. So so that's what we've got in terms of the number of safeguard measures. And then if we go to the next slide, we can see which are the most active. Yeah, here we go. Which are the most active users of safeguards? And here it's a very interesting pattern where you have India, Indonesia, Turkey, Philippines, Ukraine, Chile, Jordan in the lead, etc. The only developed country that even registers on this chart for this period 1995 to 2020 is the US, and every other member that's listed is a developing member. So, you know, it does seem that safeguards are much more used by developing members than developed members, at least over this whole period. And if we can go to the next slide, please. And this is the number of measures applied over the same period. And it's, of course, the same kind of pattern with the same, pretty much the same composition of those initiating the investigations who have applied the most measures. So again, Indonesia and India, their order is reversed in terms of applying measures, but they're both the top two, and then followed by Turkey and Philippines. Okay, that is the end of my presentation. I hope that that was somewhat enlightening and not too long. Thank you, June. Thanks, everybody.
Great, fantastic. Thank you to our hosts for arranging this event, and it's a pleasure to be with you all today. The topic I am addressing is an important matter for all trade remedies authorities looking to counter schemes used to thwart legitimate measures to combat unfair trade. My presentation will focus on the U.S. experience regarding implementation of its laws to address the circumvention of anti-dumping and countervailing duties. I want to start by providing a little perspective in the U.S. for the level of work that is underway and the importance of being able to enforce our laws. In 2020, despite operating in an environment hampered by the COVID-19 pandemic, the United States has had an extraordinarily high volume of AD and CVD activity. We initiated 119 new AD and CVD investigations based on petitions filed by or on behalf of U.S. industries. To give some perspective, this was more than double the number of investigations we issued in 2019. And during 2020, we issued 578 determinations in AD and CVD proceedings. These included such things as preliminary and final determinations issued in ongoing investigations, ranging from products such as aluminum sheet to mattresses. In addition, we issued determinations in non-investigation elements of AD and CVD proceedings, covering administrative review results, also known by some as refund reviews, covering changed circumstances reviews, sunset reviews, new shipper reviews, scope inquiries, and the main topic of the discussion today, circumvention inquiries. The U.S. currently has 42 ongoing investigations, and we administer 634 AD and CVD orders. We're at a historic high in terms of the number of orders that we administer. Despite the challenges of the COVID-19 pandemic and the extraordinary amount of work, we were able to adapt to the challenges presented by today's virtual environment, including such things as bringing new employees on virtually, training remotely, rolling out new and updated technologies in the virtual setting, and traditional teamwork and coordination of information. So as you can see here, AD and CVD orders on steel-related products make up nearly half of the total orders administered by the United States. And the number of AD and CVD orders has grown significantly in the last several years. To give some perspective, by the end of 2015, we had 322 AD and CVD orders, nearly half the number that we now manage today. Unfortunately, as the number of US AD and CVD orders has increased, so too have instances of circumvention and duty evasion. Circumvention, evasion, and fraud surrounding trade measures is a long-standing but growing problem for us, which negatively impacts the critical relief granted to companies and workers for injurious unfair trade. To combat duty evasion, our staff work alongside colleagues at our Customs Authority to ensure that the trade remedy laws are enforced and the duties that offset unfair trade practices are collected in full. We also take a direct role in investigating third country processing and other schemes designed to circumvent existing AD and CVD orders. Since 2019, we have initiated 22 circumvention inquiries. Of those 22, 13 were requested by the domestic industry, and 9 were self-initiated based on our own monitoring of trade data and patterns. During the same time frame, we've issued 20 final determinations related to these inquiries. I would like to emphasize here that our circumvention inquiries are open, transparent, and thorough investigations to determine whether the necessary evidence establishing elements of circumvention are present in accordance with our law. So under the US law, there's 4 types of circumvention we examined as indicated by the slide. The first is merchandise that is completed or assembled in the US from parts and components imported from a country subject to an existing anti-dumping and countervailing duty measure. The second category is merchandise completed or assembled in a third country from parts or components imported from a country subject to an existing US AD and CVD order. The third is merchandise that's subject to an AD and CVD measure, but that undergoes a minor alteration that brings the product outside the scope of that existing order. And the fourth is later developed merchandise or merchandise developed after the initiation of an AD or CVD investigation. Nearly 2/3 of the circumvention inquiries in the US since 2019 have involved circumvention via minor processing in third countries. So in other words, that's the bulk of our current practice in circumvention. In the vast majority of inquiries initiated since 2019, where we have made a preliminary or final determination, we issued affirmative country-wide circumvention determinations and instructed our Customs Authority to suspend liquidation and require cash deposits on entries of merchandise assembled or completed in third countries using inputs from countries subject to underlying AD and CVD orders. Where supported by case-specific facts, country-wide determinations help to alleviate the burden on industries of filing multiple company-specific allegations and prevent circumvention schemes from being replicated by additional exporters and importers after company-specific findings are made. So in terms of our circumvention work, it really falls into 2 buckets. We do monitoring and counseling. We continue to monitor trade patterns and trends closely to proactively identify situations where imports may have shifted to escape the reach of existing US AD and CVD orders. In such instances, our AD and CVD counseling staff can assist affected industries in determining next steps. In some instances, shifts in trade patterns can indicate potential circumvention of existing AD and CVD measures. Where potential circumvention is identified, we work with US industries to pursue inquiries to address the issues. In other instances, additional research and discussions with our US industries may point toward new investigations as the best course of action to address the identified issues. AD and CVD counseling staff can provide assistance to industries to prepare and file petitions to address their trade concerns. And some fact patterns identified through trade monitoring and discussions with US industries may indicate that fraud or evasion is at issue. While the US Department of Commerce can address issues related to product scope and circumvention as defined under our law and regulations, fraud and evasion issues are handled by our Customs Authority. We work directly with them to promote effective enforcement of our AD and CVD measures. Our Customs Authority investigates, for example, illegal transshipment, misidentification and misclassification, remarking of country of origin on packages and merchandise, undervaluation, false declarations, and other issues of fraud and evasion. In cases where available information indicates the underlying issue may be fraud or evasion, we direct US industries to the appropriate resources in our Customs Authority to best address their concerns. In addition, companies can report fraud and evasion issues directly to the Customs Authority via the authority's website. If we identify such issues, we bring the information to the attention of our Customs Authority. Similarly, our Customs Authority can bring issues and information to our attention for further investigation when circumvention or other product scope issues are detected. To promote effective communication and information sharing, the U.S. Department of Commerce representatives have regular, frequent meetings with our Customs Authority. And to wrap things up, I wanted to address some of the challenges that we've faced doing all of this work. As you heard, we're making efforts to work with and assist our industries in a more comprehensive way to address the broader spectrum of issues related to AD and CVD measures, either existing or potential. This is a critical aspect of our practice because the speed at which exporters and importers can adapt to avoid payment of AD and CVD duties is staggering. By the time data indicate a problem, importers and exporters have often moved on to a new scheme. This is part of the reason we've seen a trend in our circumvention cases towards countrywide. Over the years, we've heard from many frustrated industries that we've committed time and resources to successfully pursue AD and CVD measures, only to have those measures undercut by schemes implemented by foreign exporters and U.S. importers to evade the payment of duties, or to see imports shift to new sources as foreign competitors set up manufacturing facilities in new countries to escape the reach of existing U.S. trade remedies. And obtaining relief can be a long prospect for our industry. An AD and CVD investigation is a lengthy and an expensive process, but for petitioning industries who must also address circumvention concerns, much needed remedial measures can remain elusive for years. Open discussions like the one we are having today can lead to a greater understanding of the different schemes undertaken to thwart trade measures, heighten awareness of suspicious patterns of trade, and increase scrutiny by trading partners in order to combat this form of unfair or illegal trade in a manner consistent with WTO rules. And while we can't solve every problem, we hope to continue to work strategically with our industries to make clear that we consider these issues a priority. With that, I'll stop there. Thank you again to the host, and back over to you. Thanks.
Yeah. Okay. Well, thanks very much, and thanks very much for hosting the meeting. I think it's very interesting for us to have a chance to exchange views with other authorities. I want to focus my own presentation, as we discussed, on what we're doing in terms of countervailing actions, and focus specifically on that. We're of course a relatively important anti-dumping user. So I will just briefly focus a bit on the sort of trends and changes that we see in our portfolio of anti-subsidy measures, the sort of types of subsidies that we find in this context of this work, the changes in our practice, to some extent also marginally in our legislation, very much as a result of the evolution of third country subsidy practices, and maybe just a couple of ending thoughts for the purposes of the discussion. So, in terms of our level of activity, if we look at the figures for the cases initiated, and if we take a slightly longer period, we are a relatively important user of the anti-subsidy instrument, although, of course, listening to Clarice, she has identified in the numbers that we are relatively a little bit less a major user than we have been over the longer period. Of course, anti-dumping actions count for the very large majority of our trade defense activity. However, over the last decade or so, we've seen a certain increase in the level of anti-subsidy initiations. If we move to the next slide, I just wanted to give you some sense of our initiations, measures, and the jurisdictions that this concerns. We basically have seen a change in the countries that are primarily concerned by our actions in the countervailing area. In the previous decade, basically, we had primarily India, Indonesia accounting for most of our anti-subsidy initiations. India more or less representing about half of our initiations over the last last decade. Of course, this has been the case with respect to China, who accounted over the last decade for something like 40-45% of our total cases initiated. And I think the number of cases against China here reflects what we're seeing, of course, everywhere else at the WTO level in the last 10 years, where about a bit more than half of the anti-subsidy cases initiated concerned China. If we move to the next slide. So in terms of the that we find in the context of investigations in these different boxes, you see we find low-cost financing, insurances, grants, artificially cheap raw materials, components, energy and land, tax exemptions, and support for R&D and various equity packages. Now, of course, all this depends on types of investigations that we conduct, and it depends on the country concerned. When it comes to the box relating to direct or potential transfer of funds, when we have had anti-subsidy actions, for example, vis-à-vis India, this has related mainly to export credit insurance schemes. We see a much broader range of subsidy types in the investigations that we have conducted vis-à-vis China. When it comes to government revenue foregone or not collected, here again, with respect to China, we have identified in practice a fairly vast array of income tax exemption schemes. And a somewhat more narrow set of measures with respect to other cases. And in the case of the provision of goods and services for less than adequate remuneration, it's very common in the countervailing duty cases that we've had vis-à-vis China that land use rights are countervailed, and that's in nearly all of the cases. And also, depending on the industry, we have had issues related to inputs such as water or electricity. In a specific sector, in biodiesel, where we've had two cases vis-à-vis Argentina and Indonesia, here we have countervailed the provision of palm oil and soybeans, respectively. If we move to the next slide. So I wanted to perhaps give a sense of the more recent trend and recent types of measures that we have initiated and undertaken. For the first time in 2020, we have imposed countervailing duties in two cases, or what we would call cross-border financial support or transnational subsidies. In two cases, the Commission countervailed Chinese subsidies given to Chinese-owned companies manufacturing glass fiber fabrics products based in Egypt and exporting from there to the EU. And we have an investigation that has showed that Chinese-owned companies, state-owned companies, operated from a special economic zone in the territory of Egypt and received subsidies from the governments concerned and then exported to the EU. Now, this is, of course, a fairly novel practice that we have developed. The duty levels were relatively modest in these two cases, but we believe that the systemic and precedent value of these two cases here are relatively significant. If we move to the next slide, we have also countervailed in 2018, a few years ago, measures with respect to tires from China, and that involved countervailing the Silk Road Fund. The countervailed subsidies there included a package of support measures by the government of China, preferential loans, equity participation in restructuring, which we believed allowed China National Tire and Rubber to acquire an important stake in a European group. And there the subsidy amounts were more significant. We move to the next slide. Now, beyond these elements of practice and individual cases where we have taken new approaches in order to reflect the changes in the types of subsidy practice that we see, we are generally making some improvements in the strengthening of the effectiveness and the enforcement of the instrument, first through the legislative changes to our anti-subsidy instrument that were introduced in 2018. So that's on the legislative side, on the legal tool itself, with changes to the lesser duty rule as we apply it. That has been motivated by increasing concerns of subsidization practices that we have observed, and the EU on that basis decide to implement changes to our use of the lesser duty rule in anti-subsidy cases, because we believe it is not appropriate that subsidized producers benefit from the lesser duty rule under our system in these cases, and so the aim being to discourage third country governments there. And as a result of the changes to the legislation, anti-subsidy measures now fully offset the subsidies that an exporter has received, unless it is against the overall interest of the EU to do so. I believe we will be discussing these questions of public interest as well later on. We also have more freedom to investigate subsidy programs which come to light during an investigation, even if this is not being identified at initiation stage. But of course, we ensure the rights of the parties in terms of offering consultations on any such scheme found. On the territorial scope, in June 2018, we extended the application and collection of duties to the continental shelf of a member, where the consumption of the product concerned is significant. So that applies, for example, to oil rigs or offshore wind parks. And we also use the anti-circumvention provisions in our legislation. Listened, of course, very carefully to the US presentation on this. We use the anti-circumvention provisions in our anti-subsidy cases as well, where necessary, even though this is more common in anti-dumping cases than in anti-subsidy cases. Now, there was also an issue, of course, and I will finish with this, perhaps we can move to the next slide, on where necessary filling a regulatory gap, in particular for subsidies affecting the EU internal market. Despite the changes in practice and augmentation of our trade remedy legislation, there remained a regulatory gap. The subsidies provided by third countries for the acquisition or financing of EU companies were not addressed and are not addressed by the traditional trade remedy framework. Hence, the Commission adopted a proposal, which is in front of our legislative branch right now, for an EU regulation, an EU law, to tackle foreign subsidies distorting the internal market. That is in front of the European Council and the European Parliament right now, so it is not an instrument that has entered into force, but we hope and believe that this is a legislative proposal that will see passage relatively soon in order to create an instrument to protect the internal market against foreign subsidized services and investments. Again, closing the regulatory gap. Of course, for us, closing the regulatory gap also means looking at the question of the multilateral framework for subsidy disciplines and the ASCM and the strengthening of the ASCM, believe that there are gaps and inefficiencies in the current agreement on subsidies and countervailing measures. This is something which has led us, together with countries around the table today, United States and Japan in particular, to start discussions about sharing views of how the agreement on subsidies and countervailing measures could be augmented and improved, and we've done that in the context of the so-called trilateral process. This is a conversation that we on the EU side believe should be deepened and broadened, because we consider that these shortcomings of the current agreement on subsidies and countervailing measures are important enough to merit an effort of this kind, as does, in our view, the need for exchanges and cooperation in terms of the evolution of practices and in terms of the identification and evidence gathering about the problem of industrial subsidization. Work has been done in certain multilateral and international organizations. I'm thinking about, for example, the sort of work on sectors and types of subsidy measures that have taken place in the OECD context and the context of the Trade Committee of the OECD. We are supportive of this work and are always ready to engage in information sharing, again, in this important area of subsidies. So I think I will leave it there. Thank you very much.
Great. Well, thank you for being here, global webinar. And I wish you all a good morning, good afternoon, good evening, depending on where you are on the globe. First slide, please. Recent trends and challenges. Of course, global economic growth and increased two-way trade naturally leads to more investigations. Increased volatility in world markets and the desire to have duty levels reassessed because of changes in prices and input costs are also driving demand for our services. We've also seen a growing awareness and familiarity with Australia's anti-dumping system among importers and exporters, who are now actively engaging with us by making applications and submissions. The complexity of our cases has also increased. However, as is the case with all jurisdictions, the biggest recent challenge has been COVID-19. And if I go to the next slide, please. COVID-19 has changed our approach to verifications. Of course, before we used to do in country, we started by setting up a dedicated verification suite to allow our investigators to verify information virtually. This resulted in a significant reduction in our verification case time frames from around 22 weeks during the first few months of the pandemic to around 8 weeks currently for verifications. And another important thing that we did recently was we increased the specialisation of verification teams. Formerly, verification processes were part of the broader case team. But as case complexity has increased, our verification staff are able to concentrate on the vital work of auditing financial information without having to concurrently work on other aspects of an investigation. This is increasing efficiency and quality. Go to the next slide. This slide shows the total number of cases the Anti-Dumping Commission has initiated since each financial year since financial year 2013-14. While in recent years the case numbers have declined somewhat, engagement by interested parties has increased, making each case more complex. In financial year 2019-2020, the Commission considered 342 submissions from Australian industry, exporters, importers and foreign governments. Next slide, please. This graph shows how our caseload has changed over time, with the biggest changes happening in the number of investigations, duty assessment, reviews and continuations. As of June 2014, 62% of our cases were investigations, but by 2021, only 15% were investigations. Next slide, please. This slide shows the sectors that are accessing the anti-dumping system in Australia. The steel and aluminium sectors are and have been the biggest users for the past several years. Although market factors are the biggest driver of companies accessing the anti-dumping system, we also try and make it easier for all sectors and interested parties to engage with the system. We know the system can be complex and intimidating for new users. We try to help by providing extensive information on the Commission's website and through our client support service. The government also provides a free advisory service for small to medium businesses, which we call the International Trade Remedies Advisory Service. Next slide, please. This shows the number of measures in force has increased quite significantly to 2012, but have remained relatively stable since 2016. Historically, applications for anti-dumping measures have increased following economic downturns. The increase we see here is also consistent with other global trends, including overcapacity in the global steel industry. Next slide, please. Implementation trends. Domestic legislation and the WTO rules govern the Commission's approach. Under Australian legislation, I must initiate an investigation if I receive an application from an Australian manufacturer that meets the legislated criteria. But only around half of Australia's investigations result in measures being imposed. Next slide, please. My agency has an ingrained culture of consultation. We accept submissions from all businesses, whether they are manufacturer, exporter, or importer. We seek submissions and the views of foreign governments. We work across the public and private sector to inform and drive policy reform. We engage with domestic and international stakeholders, and we contribute to policy development. Australia's legislation has mandated that I convene at least twice a year a forum that includes manufacturers, importers, peak bodies, unions, and government partners. And this is called the International Trade Remedies Forum, the ITRF. The ITRF provides an opportunity for direct consultations with industry who use the anti-dumping countervailing measures. It also provides a forum to look at global developments. Working with ITRF members and other interested parties, the Australian government has agreed to a number of reforms to commence in 2022. One of the initiatives involves expanding the scope of the International Trade Remedies Advisory Service to better service small and medium enterprises. Another allows successful industry applicants to express a view on the form that the applicant considers would best remedy the injury experienced. Australia will also authorise the provision of advice to importers to clarify whether a particular imported product is within the scope of the description of goods subject to anti-dumping and countervailing measures. And we will also streamline the tariff concession order exemptions for imports. Next slide, please. As an independent statutory office holder, I lead an agency that is part of the Australian Industry, Science, Energy and Resources portfolio. My commission benefits from shared services, but we sit apart from the department. This means that my focus and my job is only to look at the evidence before me and apply the rules and laws in making my recommendations. Taking on this role as the Commissioner at a time of unprecedented challenge to the global trading system reinforced to me the need to be even-handed and to lead a system that is transparent, impartial, independent, and evidence-based. In Australia, we have one of the oldest anti-dumping systems in the world, dating back to 1906. Our system is robust and contestable, and we strive to ensure our investigations are rigorous and completed in accordance with the rules. All measures I recommend are open to merits review domestically in Australia through the Anti-Dumping Review Panel and judicial review through Australia's Federal Court. And of course, there's the WTO dispute settlement system. Next slide, please. Transparency is also one of the Commission's guiding principles. One way the Commission achieves openness and transparency is by placing on our website all non-confidential versions of submissions from businesses and Commission reports on each case. Our website contains extensive information on how the system operates, as well as details of all current measures in force. The Dumping and Subsidy Manual, which sets out the Commission's policies and practices in detail, is also on our website. My commission also has a client support team to assist interested parties to understand the anti-dumping system and find information relevant to their circumstances. Next slide, please. As I mentioned, I am an independent statutory office holder. This means that my role is to provide impartial and independent advice and expertise to the government. I look at the evidence and the facts of the case, and I apply the rules and the law. All interested parties can seek merits and judicial review of decisions. Next slide. Under the Australian anti-dumping system, the investigative authority is separate from the enforcement body. My commission conducts investigations into the alleged dumping and subsidisation of goods, whereas the Australian Border Force, Australia's Customs Service, collects dumping and countervailing duties and ensures importer compliance with anti-dumping measures. The Commission can also investigate if circumvention has occurred and can recommend changes to measures to address this. Next slide, please. In summary, the role of the Commission and my role is to provide independent, well-considered and impartial advice to government. Our processes are transparent and our decisions are evidence-based. We seek views from all stakeholders impacted by our measures. We apply domestic legislation and agreed international rules, and our decisions are subject to independent review. Thank you.
So please start, Amanda.
So good morning, afternoon, or night. It's a pleasure to be with you. So thank you in the Ministry of Economy, Trade and Industry and the Japan for the invitation. Last time I was in person with you, and this time online. Hopefully next year we can be together. I think that my presentation is on, so you all can see me, right? Okay, I'll consider that it's working. So I would like to, I have a very difficult task to talk after everybody, and I'll try to make the presentation about the recent developments on trade remedies and public interest in Brazil. My short presentation would be firstly on the status, and then I will present some data about our investigations and our measures applied, and finally some recent developments in the last few years. So what we had in Brazil is a central use of the anti-dumping proceedings. Most of our cases are anti-dumping. We have some cases on countervailing measures as well, and a very short experience on safeguards. So all our experience is based on the WTO rules, and all of them within the use of those three instruments. So there are no unilateral measures that are applied to Brazil, and we are very committed to the multilateral agreements. So what we have in terms of data, considering anti-dumping cases, this will be the focus of my presentation, is that when we consider the data, the series of data that we have in our country, we can see that Brazil has initiated most of our cases between 2012 and 2014. So we have had in 2012 47, 2013 54, and in 2014 35 new cases, new original cases of anti-dumping. And later on, of course, considering the time frame of the investigations that can take up to 18 months, we have had most of our applications of new anti-dumping cases in 2013 to 2015. Afterwards, when we consider the recent years, the 5 years, the last 5 years, we have a stability of our new investigations and the new applications as well. we consider these trends compared to the other countries, we can realize that Brazil had this peak specifically between 2013 and 2015. What we have as a consequence of this peak of original measures, taking into account that it is applicable during 5 years, is that recently we had a new peak of sunset reviews here in Brazil. So between 2018 to 2020, we had many cases initiated in sunset reviews. And as a consequence, some of them were extended, and we have a new peak of sunset reviews applications, measures that were extended their period for more 5 years between 2019 and 2021. When we consider the whole inventory of measures in Brazil, we have a certain stability of the anti-dumping measures as well. And it's important to say that Brazil has a role that we consider the impact of those measures in the society through the analysis of the public interest as well. So what we've been doing here in Brazil, well, first of all, we're trying to take this caseload that we have. It's been really, really interesting for us to see this new peak of sunset reviews, and we're working very hard to increase transparency. And this increase of transparency is due to many factors. So it's for our activity to be well known in the Brazilian society, not only within the government and not only within the industry is eventually benefiting from the measure, but also for academics, for also for other sectors that are interested in trade remedies. And then we have published, so there was a first version of the guidelines of our anti-dumping investigations. It is composed of more than 200 questions and answers about all the proceedings, what are the concepts and methodologies of our analysis, formal and procedural aspects of our investigations, as well as step-by-step on our investigation. And I'm happy to say that we're working to translate it to English, so soon it will be published as well in English, so as everybody can read it and also understand in detail our investigations. Additionally, as I mentioned, Brazil has a public interest clause since 1995, and in the last years, we have seen an increase in the demand to understand what it is, this clause. So what we've done is to publish as well a guideline with the formal procedures for having a economic public interest analysis, as well as the material criteria that we use for the public interest evaluation, and it has been published as well in March 2020. So this will as well be published in English. Finally, we published another guidelines that is focused on the Brazilian exporters that are affected by anti-dumping or subsidies or safeguard proceedings in other countries. So we are trying to make our industry aware of what is the role for the government and the role of their own business to provide information and arguments in the investigations conducted by other countries. And very recently, it's been last month, we also published a new guideline which is focused on the electronic process. So we had a electronic system that was designed to conduct all the trade remedies and public investigations proceedings, and we have just in 1st September moved all the investigations, trade remedies investigations, to a new electronic process, which is much more user-friendly and which will provide greater participation of all interested parties. And finally, what we can say is that every decision which is taken in Brazil, all the information that is non-confidential is published as well in our website, and all of them have a one-page summary similar to what we have in WTO, so as the parties can clearly understand what is the summary and the overall understanding about that decision. So what were we designing as the new developments here in Brazil? We have worked very hard on these adapting our data validation during the COVID-19 pandemic, and we had new legislation on that. We had public consultations about the parameters for sunset reviews. As I mentioned, we had a peak of sunset reviews on the last years, so we realized the need to evolve in the parameters and to give legal certainty about those parameters. So we have had public consultations, and we are trying to close our analysis to finally publish those new legislations. And finally, we had a investigation procedures about CVD. So we made the public consultations, and we are also analyzing all the contributions that we received from the interested parties, and we are aiming to publish those new regulations about CVD as well. So thank you very much for your invitation, and I'm happy to join the discussions as well. Thank you.
Thank you so much, Ho. And so let us start the Q&A session, and in the reverse order. So you may ask a question to other speaker, please. Okay. So first Amanda, followed by Bradley, Denny, Ryan. Okay. So first Amanda, please. Question to other speaker. The floor is yours.
Thank you. So I was very interested about the question, the presentation that was made from the EU, from Dennis, and I would like, if possible, for you, Dennis, to clarify what would be the analysis about public interest, the union test in the EU, but especially in the CVD cases. As far as we know, the EU has experience on anti-dumping analysis, and finally in the union interest. And we would like to know, would there be different parameters for analyzing public interest in CVD rather than anti-dumping cases? You mentioned there are differences using lesser duty rule with that. I would like to know if there's a reasoning similar to the union interest. Thank you.
Yeah, thank you, Amanda. So Bradley, please, your question.
Yes, thanks. I have a question for Ryan, just one. You stated that in a majority of cases where the US has made an affirmative determination in a circumvention inquiry, that you have done so on a country-wide rather than a country-specific basis. Could you please explain a little bit more about this approach?
Thanks. Okay, so next question session is from Denis, please. You are in a mute, please.
Yeah, Thanks. On my side, it's a question to Bradley, triggered by the interest that we have in the governance structure and the system in Australia because of the differences, incidentally, with the way we are set up. I mean, you indicated that you're in an independent statutory office holder. You lead an agency that is part of the industry, science, energy, and resource portfolio, but you also have some shared services with that part of government. I was just interested to see whether you could tell us a bit how you saw some of the benefits associated with that structure. I'm thinking as well in terms of frankly, of resources, which I guess are a constraint for all the countries concerned and represented here. Thank you.
Okay, thank you, Denis. Okay, next, Ryan, please, for your question to other countries.
Sure, thank you, June. So in the U.S. presentation, we highlighted the challenges of preventing circumvention in our anti-dumping and countervailing duty proceedings. So I was curious to hear about your authority's biggest challenge and what steps you're taking to try and address the challenge of circumvention. So thanks.
Okay, thank you, Ryan, for your question. And well, before going to the answer session, let me ask one only question to Clarice on the WTO. I recognize that the number of trade remedy measures by emerging economies in Asia has been increasing. So do you know some background of this, or are there any relationship with the trade structure or trade measures imposed by other countries? So that is my question as a moderator to WTO. Okay, so that's all questions from our speakers. So now let us go to the answer session. So first, Denis, followed by Ryan, Bradley, Amanda, and Clarice. Okay, Denis, please. First.
Sure. So on this question of public interest, well, in our case, basically the answer is very straightforward. We have a domestic legislation that mandates a public interest test in anti-subsidy, exactly like in anti-dumping investigation. So the test is identical, actually, in both instances. It's an economic test where we simply have to determine whether the imposition is in the economic interest of the union or whether or not the cost of the duty on economic operators will be disproportionate to the benefits. And we apply it exactly in the same way. There is no specificity. We apply it systematically. Of course, we have some situations where we have doing an anti-dumping and anti-subsidy investigation in parallel, in which case, of course, we only do this once. But that's basically the way in which we're approaching that particular aspect.
Okay, so Ryan, please.
Sure. So the question concerned why we in recent circumvention cases have focused more on country-wide rather than company-specific. So as I noted in my presentation, company-specific circumvention inquiry focuses on activities of a particular company and whether those constitute circumvention under our law and regulations. So as the name implies, the findings from such inquiries apply to the specific companies at issue. However, in our experience, shifts in trade patterns may be attributable to countrywide activity rather than activity by an individual firm. So in other words, it can be kind of a whack-a-mole problem. Certain circumvention schemes may be quickly replicated by other companies, resulting in a significant burden on our industries to pursue multiple company-specific circumvention inquiries for the same product against exporters from the same country. So to fully address those problems and circumstances, we have conducted a number of inquiries on a countrywide basis. And in doing such inquiries, the resulting determination applies on a countrywide basis to all products from the same country as the product at issue, regardless of producer, exporter, or importer. In addition, when we do these, we've implemented certification requirements. Those allow parties who have not engaged in the practices which Commerce have determined are circumventing the order to certify that they did not participate in such conduct. So, to ensure that we're going after the folks that we need to. This approach allows us to foreclose predictable potential circumvention schemes by applying a countrywide remedy while addressing the possibility that not all parties may be engaged in the circumventing behavior. So, Back to you, June.
Thank you, Ryan. And Bradley, next, please.
Thank you, and thank you for the question, Dennis. Yes, my agency benefits greatly from the structure that we have, where we focus on our investigations and someone else worries about all the corporate stuff. Now, we're small in size and need to maximise the scarce resources we have to best effect. With the shared services model, I don't have to allocate any of my resources to many of the corporate functions. My host department provides corporate services such as payroll services, IT and computer hardware, financial management services, and human resources services. I get allocated a budget, and I use that budget as I see fit. All the other stuff is taken care of. More importantly, though, from the shared services side of it, is that the policy arm of the pure policy arm of the Anti-Dumping Commission is actually in the host department. This is particularly important because it does enable me to maintain my independence, particularly in a situation where my minister and I might not be seen eye to eye. And that does happen, and it happened just recently with one of the cases. I made recommendations, he didn't accept them. Our system allows for that. But of course, because we have this shared services in the host department and the policy area in another part of government, it means that the minister can't take issue with me. What he needs to do is to work with the department on an alternative way forward. This allows me to focus on my mission and to maintain my independence. Lastly, I'd say, though, another benefit from having a host department, which is in our system, the Australian system, a large department, the Department of Industry, Science, Energy and Resources, when it comes to internal government deliberations on who should get what and when and how, or if I have some ideas that I would like to push along with some of the other major departments, the Treasury, the Ministry of Finance, the Foreign Affairs and Trade, it's very helpful for me to have this host department go in and wage war on my behalf. So there's some of the benefits from having the shared services model.
Thank you, Bradley. So next, Amanda, please, your answer.
Thank you. So thank you, Ryan, for your question. Regarding the anti-circumvention investigations in Brazil, I would say that we are not very preeminent in that topic. We had only 2 anti-circumvention measures that were extended, and 2 products considering many countries, but there are only 2 precedents of measures that were applied. And all those initiations, they are done by a petition from the domestic industry. So we're not used to do a self-initiation, not only for circumvention, but for all trade remedies. We have a historic understanding that we should be demanded by the domestic industry to do these investigations. Thank you.
Okay, thank you, Amanda. And the lastly, Clarice, please.
Okay, thanks. Yes, and I appreciate the question. I think it's a little difficult to know exactly all the reasons without being in the country. But I think that what I found very interesting in these presentations is that the sort of global patterns that show up in the WTO statistics seem to be replicated quite a bit in the individual country level, at least with the representatives that we have here. And I think that the reason for more engagement by emerging economies in trade remedies is very multifaceted, and it's probably not unique there. I think, first of all, we're in this context of sort of greater trade liberalization generally. We've had a lot of new manufacturing capacity coming on stream in a lot of different countries, many in Asia. We know that there's lots and lots of trade in steel and other metals and basic products. And I think, every time a new country develops a new industry, they have interests as exporters. There also may be more importations. Two-way trade, I think, was referred to by Bradley. So there's just kind of more trade, more two-way relationships, and sort of more competition, more price sensitivity. And so I think that you do end up in that sort of a situation with increased requests on the governments of the importing countries to address the trade frictions that may come up in particular situations. So that's sort of how I see it, is that as as the emerging economies more fully integrated into the world economy, particularly under the Uruguay round agreements, that these forces have played out in those economies very similarly to how they have played out in what we call the sort of original users or traditional users of trade remedies. So I think that's how I would see it. Thanks.
Mm-hmm. Yeah, thank you, Clarice, for your insight. It's very useful. Okay, so the first round is end, and do you have any further question from your side? Denny is raising your hand or not? No, okay. Okay, thank you so much. I think time is up, so perhaps let me wrap up today's webinar's Q&A session as well as the panel discussions. Actually, Clarice had a very good summary, and I can benefit from the last comment from Clarice regarding the recent trend of trade remedies in the world. So after the COVID, we are now in a challenging time. So I think today's webinar could provide us with rich information regarding the state of play in trade remedies, which are actively used by major players. And we have both long-standing issues such as anti-circumvention, as Brian described rightly, and also new challenges as Denny provided, like third countries issues. And that is perhaps a first things, so long-standing issues as well as new challenges. And secondly, as Bradley and Amanda said, the importance of the transparency or dialogue with public. So that is, of course, the important aspect. So that is the second point. And thirdly, all presentations are very much informative. It provided recent data and practices. So that is, I believe, the basis for the investigating authorities and stakeholders in the world. So that's very useful. So I believe this is also very helpful for all WTO members as well. And I appreciate again the Clarice's effort for the participation and the WTO's long-standing effort to collect data or best practices or information in the committees, which is beneficial for all. Of course, these participants as well for all the world. So again, let me conclude that I thank all your presentations, which are very much helpful for all audience, I think, and I hope that we have a further cooperation in the future. Okay, so let me stop today's panel, this stage, and pass forward to Ms. Miyata for the final remark. Thank you.
Thank you, Mr. Kazeki. Although today's session was held online due to the COVID-19 situation, we could hear significant discussion on trade remedy measures from the WTO Secretariat and other countries. Once again, I would like to express my sincere gratitude to all of you who participated. We would like to continue to work together to ensure a level playing field while sharing information about among investigating authorities. In addition, today's discussion will be beneficial for Japanese industry. Based on today's session, we will make further efforts to ensure that the industrial sector can use trade remedy measures for more effectively. Finally, I would like to speak to the audience of today's seminar. If you are troubled by the unfairly low prices of imported goods, please feel free to contact us. I would now like to adjourn today's seminar. Thank you very much. Okay, recording part is over now. So please be relaxed.
Thank you. Thank you so much. And, yeah.
Bye. Thank you.